No. Greetings to everyone. Happy season of Thanksgiving as we are leaning into that season even more and preparing our hearts and minds for Advent. It is an exciting opportunity that we have tonight, both from the Central District and sharing space with Metro Ministries and the United Methodist Foundation of Indiana to engage in learning and gain information about how we can better be prepared in planned giving and what resources and opportunities are available. My name is Reverend Dr. Elise Fulbright, and I serve as the Conference Superintendent of the Central District, where we continue to strive in living out the mission of being Christ-centered, community-connected, and missionally centric. And I'm going to turn it over to Tina Mackinac to be able to share greetings regarding Metro.
Thank you, Reverend Dr. Elise. Again, I'm Tina Mackinac, and I am the Executive Director of Metro Ministries. And we are happy to be with you this evening, whether you are here in person or you're watching the recording after the fact. I don't want to take any more time than necessary. I'm not here to tell my story. So would love to just move right into introducing you to Manet Shettle. Manet is the president of the United Methodist Foundation of Indiana, and she is here this evening to share with us on ways that you can give beyond the checkbook or cash, and some ways that, and some of the benefits to non-cash and planned giving. So Manet, I would love to turn it over to you right now.
Sure. Well, thanks. I will share that if there are questions, it always gets me. This is going to be a lot more interactive than just me talking. So if you've got questions, there's a few of us, you probably can kind of butt in and just say, hey, wait a minute. Or if you want to, you can put it in the chat and Tina's going to be following that for us and she'll butt in for you. But either way, I'd rather you ask those questions than get to the end and not have the information that you need. So we are going to talk about, I like to call it legacy planning because this covers a whole lot of things. And the first part is we're going to talk real brief and pretty high level over a lot of things. So again, that's where if you've got a question, you need to stop me and dig in a little bit. So we're going to start. When you start thinking about legacy planning, we talk about the 4 Ps: the people, the property, your purpose, and the process. And the first 3 I'm going to touch on just briefly because that's really something you have to define for yourself. The process is what I hope to give you some tools that you can then go forward and accomplish what you want to. So when you think about people, spouse obviously is one that most of us think about, children, grandchildren, special relatives, friends, the ones a lot of times we forget about, the people that are in the ministries that we are serving in and we love. So when you start thinking about the people you want to support with your legacy, make sure you don't forget the people that are in those ministries. Your stuff, your property. I've talked to so many people over the years and they'll say, oh, well, we don't really have that much. And then you start talking to them and it's like, well, you've got a house, they have a car, oh, well, yeah, they do have. When you start looking at a legacy, it's all of your stuff because the reality is you're not taking it with you. So it's helpful to actually start making notes of all the stuff you have and where you have it, particularly if you have an executor that's not going to be your spouse and wouldn't know. Honestly, even my spouse doesn't know where all of our stuff's at. So I have a list even for him. Purpose. What do you want to accomplish? And here's, I'm going to divert just a little bit because what you want to accomplish is going to be as unique as each one of us and can be different between a husband and a wife. My husband does not participate in the church. He's not even a CNE. He doesn't even go to Christmas and Easter anymore. I obviously am very engaged in the church. So what I want to accomplish with my legacy planning is very different than what he wants to accomplish. So you really need to think about that and consider what you particularly want to, because there's lots of ways that you can get to the end. There's not just one direction forward. So process, we're going to talk a lot about. This is what the next hour or so is going to be. There are a lot of things to consider when you start thinking about how you can accomplish what you want to. And there isn't a right or wrong answer for any of them. So we're going to look at all of those different things in a little more detail. Some things you need. Everybody over the age of 18 actually should have a will. And we're going to talk about wills a little bit in detail, but just pen that one. If you don't have a will, you really need to get one. And it's amazing the number of people in the United States that do not have a will. Trusts, that's going to be, we'll talk about trusts. You may or may not need a trust. The advanced directives is one that, particularly as we age, I would strongly suggest this. Some of those advanced directives, your healthcare representative and living well, are crucial even for younger people. And I'll give you an example of that. My daughter turned 18 a few years ago, but she turned 18. She was still a senior in high school, which, you know, you would think, okay, she's still at home. But reality is, with HIPAA requirements, if she'd been in an automobile accident or had any kind of health care where she could not make the decisions for herself, we would not have just immediately been the ones that could walk in and do it. So having the healthcare representative named, having your living will, which is your healthcare directive, is a critical piece. Letter of instructions, the document locator, again, that's very helpful even for your spouse, because sometimes they don't know where all of your accounts are, your credit cards, what the passwords are for things. That's also very helpful. And then the plan of service, you know, we all have different ideas of what our funeral service would look like. And it just is really helpful to have some of those ideas jotted down. Do you plan on having your funeral in the church or in the funeral home? Do you want to have a graveside service? All of those kinds of things. And if you've got a particular song or scripture that you want read. Documents. So now you've got all your documents. What do you do with them? You need to keep the original, I suggest, off-site, preferably in a safe deposit box or with your attorney. I know a lot of people think, oh, I've got a fireproof safe at home, I'll be fine. The reality is those generally are not fireproof, they're fire resistant. And at certain temperatures, the documents inside are going to burn up. So it's helpful if they're off-site. You do want a copy at home so you can look at it, and make sure that if you have executors or personal representatives, that they also have copies. How often do you review? And this is one that I think catches a lot of people by surprise, because you do your planning and it's like, okay, now it's 15 years old. Well, things change. Things in your family change, but also things in the law change. And so it's helpful to look at these things about every 5 years, particularly if you've had any kind of change in family circumstance. So you've had a child born, a grandchild, you've got married, a spouse has passed away, any of those kinds of things. And also be aware of the health of the representatives, your personal healthcare representative, your executor, if you have guardians, because sometimes they are no longer able to fulfill what you would ask them to do. Now, I didn't go into this, but I am a CPA and was on the public audit side for a while, and I audited a lot of trusts. And this is kind of from some of those experiences in auditing those trusts. Some of the information that people put into the trust documents, into wills, is just really hurtful. And the reality is, it's not going to help any to lash out at people. I did see some where they tried to control the people's behaviors. So a drug addict, somebody like that, and they put it in a trust. Well, the reality is you are not going to be able to control what they do just by saying don't do it. There are ways to do it, and you can set up trusts that might support them, but don't put it in a will that says so-and-so was, you know, a drug addict, and if he gives up, then he can have this money. The other one is being too rigid. And that's obviously, you hear stories about that, but a personal is, I have had a nephew and a niece who one of my great aunts and uncles left them scholarship funds. The problem was they were for university, so they could be used as a university. My nephew had some serious health issues and actually was never able to go to college. He could have gone to a trade school probably, but he wasn't able to access those funds because they were too specific. You see the same thing in a church. And I'll give you an example. In my church, we have a pipe organ. We had a gentleman years ago that was our organist, and he left an endowment to maintain the pipe organ, which is great as long as we have a pipe organ. The reality is sometime in the probably not too distant future, that pipe organ is not going to be able to be repaired. And now we have an endowment that at the best we'll have to go to court to have it repurposed. So leave some flexibility in your legacy planning. I am going to hit Medicaid, Medicare issues because this is something that we hear a lot about and people get pretty confused. So what you hear about is that if you give a donation, Medicaid is going to come take it back, or they call it a clawback. What actually happens? First of all, Medicare is insurance. And if you're worried about your insurance, it's just like any other insurance plan. They aren't going to take anything away from anybody. As long as you pay your premiums, they're going to give you coverage. What happens is if you become destitute to the point where you can't pay your bills and move into Medicaid, that is emergency financial support. In those situations, they have a 5-year look back period. If you've made donations or gifts, so if you've given your child a significant sum, if you've given something to the church, they will push back the time that your coverage will start with Medicaid. And we see this in some problems where people do need that financial support. But if that's an issue, there are ways to maintain the gifts that you want to give and still be able to benefit. But it's going to take an attorney who really understands those Medicaid and Medicare issues. What I really want people to think about, though, is this isn't something that most of us are going to have to worry about. Be aware of it, but don't stop your gifts just because you think that they'll pull them back. That's not the way it works. Okay, we're going to start into wills. And the first thing I want to talk about, and this is how property transfers, because it's very important that you understand that if you're distributing all of your assets, you think through your will, the assets may be a lot less than what you think is going to be in there. So if you have what's called joint property, most of your bank accounts, your homes, your cars, anything that you and your spouse or you and your child are on, that's called joint property. What happens with that is when you pass, they take complete control. So if you think of a bucket and you put all of your assets and your estate in that bucket, anything that's joint property just got pulled out of that bucket. Contract law, so your life insurance, your retirement accounts, if you've named a beneficiary, those are going to distribute next. So if I have a life insurance and I've named my spouse as the beneficiary, he's going to get all of those. It doesn't go into my estate. It won't be distributed through my will. If I've said that there's no beneficiary or the beneficiary is the estate of Manet Shettle, then it goes into the estate. Trust law, if you've created any kind of trust, the trust law is going to distribute next. And only the things that are left in that bucket now are going to be distributed under your will. So that's important to think about if you intend to divide all of your assets equally between your two kids, but one of your children is on, let's say, the beneficiary of your life insurance, or maybe is on your bank account because they're helping pay your bills. So types of wills, and this first one, I I didn't think I would ever see it. And I was in one of these a few years ago and had somebody tell me they had one. A joint will is where you actually have two people on the same piece of paper, basically. So you have one will that says this will is for Daphne Manet Shettle and Stephen Patrick Shettle. That's my husband. The problem with that will is once you pass, your will can't be changed. But if my husband passes and I'm still alive, now I have a document that I can't change, but I should be able to. So they really have been disallowed, and actually some courts will consider that you died intestate if you have a joint will. You can have what's called a simple will, which basically leaves everything to your spouse. And I leave everything to my spouse, he leaves everything to me. And those are simple reflective wills. That's okay. It's just having one document that actually covers both of you. There are some advantages to a simple will. There's some disadvantages. Obviously, one of the huge advantages is that it's simple. It's easy to put together, and it's not going to be very costly. It doesn't allow you to do some of your legacy plannings, but here's one of the ways that you can think about this. My husband, as I said, is not really into the church. I am. We both have a simple will. So I've left everything to him. He's left everything to me. But through one of my IRA accounts, I have created an endowment when I pass that will be funded with that IRA. So you can accomplish what you need to, not necessarily using your will. The pour over will, if you have trusts, you actually need to have what's called a pour over will. And basically what it does is just goes out and collects all the assets that isn't in the trust, puts it into the trust so that your trust is actually the final document that distributes all of your assets. Okay, die without a will. What does that do to you? Well, first of all, the state will actually distribute your assets. Fine, as long as you don't have any other concerns. So if you have a guardian for children, you're in trouble. If you wanted to make any charitable gifts, not going to happen. If you had friends or maybe extended family, not going to happen. The state has a very specific distribution: spouse, children, parents, depending on what your circumstances. And that's one of the unintended consequences that can happen with intestacy. If, for example, if you're married and you have no children and your parents are still alive, your spouse does not inherit 100% of your estate. Your parents will inherit a percentage of your estate. And a lot of people don't realize that. Again, if you have children, growing children out of the house, adults, they don't need extra income. If you pass, they still inherit part of your estate. Your spouse would lose some of those assets. So it's worth the effort to make sure that you've got a will and allow it to do what you want to do. So creating a will, not all that difficult. Definitely use an attorney though. I know you can go online, you can get the blank copies, but there are reasons, and two of them that I'll give you. One, there are specific people who can and can't witness a will, and you may or may not know who those people are. An attorney is going to know that. There are laws that change, and the wills that you get on the internet may or may not apply to the state that you live in. There's lots of other reasons, but definitely have your attorney. You can do a lot of things to decrease the cost of the will. You can go in, know what your assets are, what you want to do. You can be pretty specific with giving them direction, which allows them to write it up much more quickly than if you're sitting in their office for an hour and a half talking about what you want to do and what stuff you've got. You do have to be 18 years old or older. It has to be in writing. And you have to have capacity, which basically if you wait and are diagnosed with Alzheimer's, you're not going to be able to create your will at that point. So I haven't heard any questions yet. Anybody got any burning issues? Everybody understands you're all on board with what we're doing. All right. Okay, trusts. There are a couple of different kinds of trusts that we're going to talk about. I'm going to focus primarily on the living or the testamentary trusts, or I'm sorry, the living trust, not the testamentary trust. A testamentary trust is a trust that's created through your will. So you die, your will distributes your assets. A lot of times we'll see those, particularly if you have a spouse who has Alzheimer's or something, you want to create a trust that will care for them. Maybe you want to create a trust that will care for grandchildren. There's lots of ways to create trust through your will. And there's times that is beneficial because the person receiving those assets doesn't have the capacity for any number of reasons to actually manage those assets. A living trust, you can create a revocable or an irrevocable. Revocable, you hear a lot when somebody, they want to go to Belize. Not that anybody's going to Belize, Tina, but if they want to go to Belize and they don't want to have to pay their bills, they can create a revocable trust with a trustee who takes care of all of those types of things. And it's just what it says, it's revocable. So if they come back and they aren't happy, or maybe now they've decided to stay home, they can revoke it and all the assets return back to them. An irrevocable trust is one that you cannot change once you've set it up. And there's a couple of reasons. The charitable trusts, obviously, because you've received a charitable contribution for that. And if you go to change it, then you would have to revoke that charitable deduction. We're going to talk a little bit, and I'm going to show you how a charitable remainder trust works, and then I'll throw in there a charitable lead trust, because we have started to see those come back into popularity. But a charitable remainder trust, the idea is that you're going to give a gift to a charity, and a charity that can manage the trust, because you're going to receive an annuity payment the rest of your life. And that payment can be calculated a couple of different ways. It might be an annuity, so it's established, and this is what you're going to receive. The amount doesn't change. It could be what's called a unitrust, where it's based on a percentage of what's in the trust balance. Those are things that you can work out. You can receive that payment. You can have it for 2 lives, so it could be for your life. And you can also identify what are called annuitant beneficiaries. So when you both have passed, you can have someone who receives that annuity payment for up to 20 years. Now, let me give you an example. The foundation managed a charitable trust for a farmer. He had cancer, realized that he did not have long to live. So he created this charitable remainder trust. It was for him and his wife. He passed pretty quickly. In the trust, they created a 10-year payout to their children. So they had a son and a daughter. They donated all of their farmland to the foundation. We sold it, created the trust. His wife received an annuity payment for the rest of her lives. His 2 children actually have received their annuity payments. And after the 10 years was up, then he had it distributed actually to his church. They are now receiving the annuity payment, or not the annuity, they received the remainder that was in that trust. So some advantages and disadvantages to a trust. Advantages, you have lower probate costs. So when you die, the trust is already there. It's already in place. So you don't have to go to an attorney. You don't have to have an executor, that kind of thing. There is more privacy in the information because a will is a public document and has to be filed with the court. And you have a little more control because you can say specifically who does what. The settlement time also, that's probably one of the biggest things, because as soon as you pass, the trust is enacted. With a will, you've got to go through probate, and it can take several months to actually finalize your documents. And it does help if you've got out of state, if you own property, say in Florida, a trust has some serious advantages over trying to deal with it with a will. It is going to cost more up front because you've got to create this document, and most trusts are going to require IRS filings. Some special situations. Actually, one of my predecessors has a special needs daughter, and he had created a special needs trust to care for her in case he passed before she did. The idea behind a special needs trust is just that you are going to provide supplemental assistance to a loved one. with the expectation generally that they're going to receive, generally it's Medicaid support. And those trusts need to be written very specifically so that they don't get invaded and spent on just kind of the mundane support that you want. The quality of life, I guess, is the point behind a special needs trust. You do want to have an attorney that knows how to work with special needs trust and an executor or trustee that manages it, that understands how to manage those, because they usually get pushed pretty hard. So now we're going to talk about some gift planning ideas. And these are things that you may want to use to fund gifts now, or maybe something that you will look at later on. We're going to talk about some of them in detail. I do want to point out again, there are ways to gift some of these things. So life insurance is something that you can gift to a charity. You can name them as the beneficiary of your life insurance. If it's a term policy, you may have some problems, but if it's what's called a whole life policy, you can actually give that policy to the charity, and then they can choose to make the payments. You could choose to make the premium payments. A lot of times they're paid up and they can just hold it until you pass, or they can actually cash it in. So there are some life insurance things that you can do. Obviously with your IRA or 401ks, you can name the charity as a partial or a complete beneficiary. The other things we're going to talk about in a little more detail. So deductibility, one of the things I've heard on more than one occasion is, well, you can't deduct anything anymore. And that's just not the case. You can still deduct. It's just that the standard deduction is a little higher than it has been in the past. So a lot of the things that we've always talked about still exist. You cannot deduct donations of your time, but most of the other types of gifts that you give to a charity, you can deduct. There's a 50% limit on your adjusted gross income, and there is a limit on capital gain property. And we're going to talk about capital gains, why those kinds of properties are sometimes better to give than just a cash gift. Deductibility rules, again, if you exceed that 50% AGI, you can carry it forward for 5 years. You do have to have appraisals. If you're giving property, you do have to have appraisals for any donations of over $5,000. And that's the donor's responsibility to get that appraisal. And then the standard deductions. And that's going to come into play here in just a minute, because there's a way, if you can bundle your gifts, where you may have the advantage of itemizing 1 year. And if you bundle your gifts, then the next year you use the standard deduction. And I want to show you what I'm talking about with this. So let's say you tithe to your church and you give $6,000 a year. So in 2020, every week you gave whatever 52 of 6,000 is. And then at the end of the year, you were able to make a donation of the next year's pledge. So you go ahead and pay your pledge in December. So that year you gave $12,000 to the church. The next year, you're not going to give anything because you've already given your pledge. Throw in a couple of other gifts. In 2020, you could have taken your itemized deductions. So you would have been able to take $12,700 instead of the $12,400. And in 2021, you just take the standard deduction. So when you bundle gifts like that, you have some opportunities that will have tax benefits, which just gives you more money to be charitable with. So appreciated property. So these are stocks, land, anything that has appreciated in value. And we were talking about some appreciated assets. There's some huge benefits if you've had any kind of significant appreciation in those values. So if, let's say you've got a stock, you want to give $100,000 to Metro Ministries. I'm guessing Tina would be happy to take that off your hands for you. If it was, let's say, that you're a basis. So if you have stock, you bought it for X amount. So if it was $60,000, you would pay capital gains on $40,000 if you sold that stock and gave the $100,000 to Metro Ministries. If you give the 100,000 to Metro Ministries, they're a tax exempt organization, so they don't have to pay the capital gains. So Metro Ministries still gets 100,000. You just save the tax on 40,000. So there's some advantages to being able to donate appreciated assets. And I'm not going to go into a lot of detail here, but I'm just going to say sometimes the asset that you're giving is too large. You can't afford to give the whole asset. You might want some compensation. And that's what's called a bargain sale. So instead of, if I've got a $200,000 piece of land, instead of just giving that piece of land, I might ask for them to pay me a certain amount. Now, this is something you're going to have to work out with the charity that you want to give it to. But if they gave you 80,000, then the transaction is actually split between those two. So 80,000 is going to be considered a sale. You're going to pay capital gains on the related capital gain that you recognize. But the part that's in the gift, you're not going to pay the capital gains. So hopefully that makes sense, but just stick that in the back of your mind. If that's ever an issue, there is a way to recoup some of the cost if you can't really afford to give all of the appreciated asset. So required minimum distribution. This is another big area, and particularly this time of year is when we start seeing it. So your RMD, there's been some changes in that. It used to be 70.5, now it's 72. If you're over 72, you will be required to take a distribution from your IRA or your pension plan a lot of times. You can make what's called a qualified charitable donation, or QCD, from your IRA, not from your pension, but from your IRA, from that required minimum distribution. And it has to be distributed directly to a charity. The advantage for you is while it goes toward your RMD requirement, it is never included in your income. So if you can't itemize your deductions, so you're just taking the standard deduction, you just were able to take an itemized deduction that you otherwise couldn't. It also, you have a lot of times limits with your Social Security benefits that will be taxable, the cost of your Medicare insurance based on your income. And again, it's not included in your income, so it has some other benefits. So rolling that RMD to a charity has some huge advantages beyond just getting the charity some support. Be advised, there's two things you need to be aware of. With your required minimum distribution, the first dollars distributed go to meet that required minimum distribution. So let's say if you're required to take $6,000 out of your IRA and you're taking $1,000 a month, so you're taking $12,000, you can only do that QCD in the first 6 months, because by June you will have met your required minimum distribution. If you wait till December, you won't be eligible for the QCD. And the other thing, and this is just a really weird quirk of this whole QCD thing, the IRS does not allow you to create a donor advised fund from your QCD. So you can only distribute it. You can't create a fund that you can go back and distribute. So we're going to look at charitable gift annuities. This is going to look a lot like the charitable remainder trust. Usually you see people use charitable gift annuities when they have a smaller amount. The charitable gift annuity, you're going to, again, donate to a charity. You're going to receive an annuity payment over your life, and it could be over the life of you and your spouse or anybody. It could be a friend, a child, anybody. Here's where it starts to differ. That's it. Those are the only two people who can receive the annuity payment. There are no secondary beneficiaries for that. The remainder then will distribute to your charity. I will say one thing to be aware of, it depends on who's managing your charitable gift annuity. Sometimes they manage on what's called an individual basis, which means whatever's in your pot is what's distributed at the end. And that's fine if you die sooner rather than later. If you live too long, there's nothing left to distribute to your charity. Some manage on a pool basis, which usually they will guarantee a specific minimum and maximum payout. So you do want to make sure you understand how the charity is managing their charitable gift annuities. Endowments. So a lot of things that are misunderstood about endowments. Everybody just assumes an endowment has to be permanent, and that's not the case. It may be temporary, and depending on what you've created or what you've set up, it may be required to be considered a temporary endowment. So for instance, if you say, here's $50,000 and I want you to distribute $5,000 every year to Metro Ministries, that's a temporary endowment because potentially you could distribute the entire amount if we're required to distribute 5,000. And there are other reasons to have a temporary. We have just distributed one, actually. We had a lady who created an endowment with us, and for the first 20 years, it went to support missions at her church. There was a clause that if the church built a sanctuary in that 20 years, that the endowment would end and the full remainder would be distributed to the church for the sanctuary. If after 20 years they hadn't built the sanctuary, then it converted into a permanent endowment, and then she outlined who would receive the benefits. So there's just a lot of flexibility with an endowment. You can have a specific beneficiary as in that purpose. You can have just a general missional, purpose behind it. You can have multiple ministries that are supported. You can have, as I said, the min or the max distribution amounts. That termination clause, remember I mentioned early on about the pipe organ in our church. If he had just put a termination clause in there that said, if at any point in time the pipe organ ceases to be a viable instrument for worship, this endowment can be used for other areas of worship or other areas of music or anything else, then we wouldn't have to go to court and have it repurposed. So that termination clause is very helpful because let's be serious, things change. So you should always think about what happens if, and then what would I want to happen to that endowment. You can start an endowment during your life. We have several who have created the endowment and have not funded it or have minimally funded it and intend to fund it with their gifts from their estate. We also have some people who have, they want to be able to itemize their deductions. So they've started funding it and will continue to fund it through their lifetime with no intention to have an estate gift. You do want to have a detailed documentation of what your expectations are. If you have created the endowment, then you're going to have an endowment document. If you have not created the endowment, then you should have a letter of understanding that says, oh, I've assigned my IRA to distribute to the church, and this is what I want you to do with it. Again, funding endowments, and we've talked about all of these before. So there's lots of ways that you can go through and fund an endowment if you want to. And now we're towards the end. So things to think about. I'm guessing that possibly there are a few questions left that you have. So you need to figure out what those are, and you feel free to call us. We're happy. Glenn or I, either one, would be happy to meet with you, talk with you, work through any of those issues. You may have a tax accountant, personal financial planner, somebody, attorney that you might want to work with. But get your questions together and then get that additional information. This is one I push really hard. Talk to your people. And when I mean that, talk to your spouse, talk to your family, let them know what you're wanting to accomplish, why you're doing what you're doing, even if it's an uncomfortable conversation. This is why I say that. I'm a CPA. Great. I have 2 older brothers. I have 5 cousins. One of those families where my grandmother was one of 11 children. She and one of her sisters are the only 2 that have children. So now you're down to the one sister's child did not have any children. So my grandmother is the only source of our generation. What that means is I've had several great aunts and uncles who, when they passed, I was made the executor of the estate through their will. And I have some cousins, and as I said, I have older brothers who at the time were less than thrilled with that. And it was just because they didn't know. I mean, once we worked through it, then they were all okay. Fortunately for me, but I have seen some ugly, ugly fights that could have easily been prevented if mom and dad just had sat down and said, you know, this is who's going to be the executor and this is why. If you want to create some kind of a gift with a charity, make sure you've talked with them about it as well. There's nothing worse than saying, I want this money to go to this charity and I want them to do with it whatever. And the charity's going, yeah, we can't do that. So it really helps have that conversation, get that letter of understanding so they know when your funds come, what you want to do. Another quick example of that, worked with a church that got $1 million gift. They had two elderly sisters who were both teachers. Neither of them ever married. They lived in their family home their entire life. I think one was like 97 and one was 95, or maybe 95 and 92, something. They were both, and passed within about 6 months of each other. So suddenly they have this $1 million estate. There were so many people in that church that knew exactly what those sisters wanted done with it. And there were probably as many different ideas of what to do with it as there were people in the church. And it actually caused a pretty big division in their church. So it's so much easier, just clarify, what do you want done? It's your money. What do you want to support? And then work with your legal advisors, your financial planners to get the documents in place, because that's probably the biggest mistake I see. People do all these plannings and they have all these ideas and they never get the documents in place. And so they don't accomplish what they wanted to because they didn't have in place what they needed. I told you we were going to go fast. Any questions?
I got a couple, Manet. On the minimum IRA distribution, I'm 70, so it's going to be 72, right? That's what it is now.
If you were 70 and a half when they made that change, you could still continue to take your RMD and do the QCD.
Okay.
But if you were not 70 and a half when they made the change, then yeah, you're going to wait till 72.
Okay. Now, does it have to be sometime during the calendar year you turn 72? Is that the way it works?
And you're getting into some detail, but I believe that you will be required to start your RMD in the month that you turn 72.
Okay. All right. One other one. As far as the IRS is concerned, or the law is concerned, I don't know if I'm going to ask this right, but how do you know that a charity is legally registered or legitimate before you make a donation?
Sure. And there's any number of ways. There's a place called Gold Star, and you can, Guide Star, sorry, Gold Star. Gold Star is a whole different group that we work with, Guide Star. And they have a whole list of registered organizations. Now, here's the thing. You have to register on that list. So some of the smaller charities might not be on there. Certainly you can ask to see their 501c3 letter. And if
what was that again? 501c3?
It's called a 501c3 letter. It's basically a letter that's from the IRS that says, yep, you're a charity and we recognize you as such.
Okay.
And any reputable charitable organization will be happy to provide that for you.
Okay. Those are the only two that I had.
Okay, I just say here's the overarching thing with the United Methodist Church. A church may not have that letter, but if they're part of the United Methodist denomination, they are automatically under the umbrella United Methodist denomination
Okay.
letter.
Okay.
Manet, just to tag on to that, I've had donors ask explicitly for Metro's EIN number for an RMD distribution. Is that always? I assumed it was required, but is that typical that if you can get that you would need for, or maybe it's for a trust. It may not be for an RMD distribution, but
Yes.
are there some cases when you may want to provide an EIN?
Yes. Now that, yeah, I didn't say for the RMD, I don't know why they would need that. But if you're creating a trust, then they're going to identify the trustee and they have to identify the organization, the entity that's going to be the trustee. So in a trust, they would need your.
And I just had a question on kind of the order of the process. Everything sounds really complicated and overwhelming, but when I take a step back, it just seems like there are a lot of steps and it's not really that complicated as long as you know kind of the execution order. So what is the best first step? Do you need to go to a legal advice? Do you need a letter of, so if you know, like, for example, let's say you know you want to donate to a church or to an organization like Metro Ministries from what you expect to be your estate. What's the first, is it the letter of understanding with the organization, or do you go to your tax advisor? What's the real first step?
Yeah, and I would go to the organization first and say, gee, I want to do this, and this is what I want to accomplish. So let me use Metro as a great example. I come to Metro and say, you're going to be part of my estate plan, and I'm going to leave 10% of my assets in my will is going to be distributed to Metro Ministries, and I want it to support operations. So at that point, you can say, okay, that's great. But what if I said, well, I want to do all of this and I want to provide a scholarship to seminary for anybody who lives in Indiana. Well, then that's where, and I'm using that example because we've worked with this, that's where you may say, well, that's kind of out of our bailiwick. Maybe you want to go to this group and consider it. So that's the first step, is to make sure you can do what you want to do and they're willing to do what you want to do. Once you kind of got that worked out, then you're going to go to your financial planner and say, okay, how is it best to do? Is it best to leave 10% in my will? Or would it be better to assign this IRA that I have that is small, but it's about the amount that I want?
Thank you.
So I guess it's somewhat related to that. I think you've already covered this. Suppose you have a non-cash, say securities, that you wanted to donate to Metro. So I email Tina and say, Tina, I've got X shares of ABC company. I want to donate them. Would we CC you on that, Manet? And and the financial planner, how does that exchange all come together?
Right. And this is a little more specific because we process those stock donations for churches and Metro Ministry, any United Methodist related. So what happens is you're going to say, Tina, I'm sending money in and I want it to go for operations, or I want it to go to Brightwood, or whatever I want to do with it. So she needs to know what you want to do with it. We need to know that you're sending that money in. So we've got a form that we'll have you fill out that says, I'm giving you 15 shares of Apple stock and I want you to give it to Metro Ministries. And what we do then is receive the Apple stock, sell it, and transfer the money to Metro Ministries.
Okay, but we would need the actual holder of the securities to somehow know about this. So it sounds like it's a longer email address kind of thing where Tina, you, and a financial planner, as well as myself or whomever, would need to be involved with that whole communication of desires and amounts, et cetera.
Right. So, and usually whoever's holding your stocks, I mean, you've got a broker that probably is holding your stock. The foundation will provide those two, well, actually we'll provide 3 forms. One is the form that you give us that says, this is what I want done with it. One is the form that's called the DTC, which is the instructions, the transfer instructions. And that you just hand to your broker and say, now I want this much. And then the broker probably is also going to have some kind of form that authorizes them to transfer those funds. And that would, each broker is going to be a little different.
Okay. So the initial contact would put all of that in motion to get the forms distributed to the right people and eventually get filled in and then submitted.
Yep.
Then all behind the scenes kind of things happen and the money goes from broker to foundation to Metro.
Yes. Yeah.
Got it. Okay.
Anything else?
I'll just mention this, maybe not so much a question. I sat in on a philanthropy discussion with Jamie Levy and one of his associates, and his advice to organizations that were in trying to encourage contributions to endowments, it was very specific, was don't be afraid of the conversation. Ask people and things will move forward at that point. What would be your advice for us as Metro Ministries along those lines? Since I'll just make a general broad statement, none of us are real financial wizards and don't really have all the wherewithal to discuss the ins and outs. How might we, as an organization, engage in those kinds of conversations with our prospective donors? What would be your advice for us, Manet?
Sure. Well, and the first piece is very rarely do you get it if you don't ask for it. So yeah, definitely ask and share information. And some of it is, I mean, you start a conversation with somebody, you know, and that conversation is going to be pretty generic. You know, we have this idea and, you know, we'd like you to consider an estate gift. As the conversation moves, if you start moving into areas where you're not comfortable, I mean, you are comfortable in asking, we have a wonderful ministry here and we'd like you to financially support it with your estate gift. That part you can handle. And it may just stay at that level. If they start asking really specific questions about how can I accomplish that, that's where Glenn or I are happy to come in and participate in that conversation. We won't ask for you, but we'll certainly be there to share how they might be able to do it. Again, we're not financial planners. We can't legally do that, but we can certainly give them some ideas to send them back to their financial planner.
Okay. It's very helpful. Yeah, this is where I think all these nuances of what the terms mean and who does what. And as Tina said, the sequence of how the conversation is managed.
Absolutely. So, and that's what you've got my contact information there. As I said, I'm happy to talk with you. Glenn Howell, if some of you might know Glenn, we still are 10 years later. He's former South, I'm former North, but Glenn has actually gone through the School of Philanthropy with IU. So he has a lot of this background as well. And I'm a CPA. So between the two of us, we probably can come up with an answer.
Great.
Thank you.
That's great.
You're very welcome.
And Manet, we are still recording, and I think you're host, so that means you will get the recording. If you want to share it with me via whatever whatever means is the easiest for you, just let me know. And I will, because I want to get it a link into, I want to put it on our YouTube page, our YouTube channel, and get it so we can link in our newsletter and so forth, as well as share it with the Central District that way as well. So
Sounds great. I'll probably put it in Dropbox. That works.
perfect. That'll be perfect. Okay. Well, Manet, thank you so much. This has been, Dr. Elise needed to drop off early. She had she double booked herself. I think she usually quadruple books herself and somehow manages to get all touch points done. But so she had to drop off. But thank you so much for all of the information and the presentation. I think you had asked about, or you said that you often get requests to share that. So is that something you'll be able to share with me that I can have to distribute as well?
Can do that. We'll put both in the Dropbox.
Perfect. Okay. Thanks so much. Deanne or Tom, do you all have any other questions? I think we're the only ones left.
Nope, all good.
I'm
Thank you.
good. Thanks.
Okay. Okay. Thanks so much, everybody. Take care.
Have a great evening.
Good night.
Happy
Good
Thanksgiving.
night.
Happy
Thanks.
Thanksgiving.
Yeah.